Welcome to this week's OK at Work with myself, Sarah Sawyer, and my colleague, Russell Berger. And we're both labor and employment attorneys with Offit Kurman. And today we are talking about parental leave and medical leave and Title VII. So a lot of policies that I look at are, lump all of these things together. Parental leave, for women, a certain period of time, let's say 12 weeks, and then, 6 weeks of parental leave for fathers, for new fathers. And that is a big issue. Why is that an issue, Russell?
I feel like I'm in law school. Put me on the spot. So the issue is Title VII is the anti-discrimination law that applies to gender. And so if you run these different types of leave together, you can have imbalances. So really the distinction is that a woman who gives birth is going to have time for recovering from the act of giving birth, is going to have probably will certainly qualify for a short-term disability. Whether you have a short-term disability policy or not is a different question, but you have that bucket of needed leave, and then you separately have, or could elect to have, a bonding time bucket. So bonding time is gender neutral, meaning that whether you're male or female or non-binary, or you give birth or you don't give birth, bonding time is equal to all parents of all genders. Conversely, the recovery time from giving birth is specific to a woman who gives birth. So the idea in the law is that if you run those together and you mush it all into one amorphous leave, you could be depriving the woman who gives birth of the additional leave, the recovery from birth aspect of the leave. Conversely, you could also, men could have a gender discrimination claim if, they're getting less than what women are getting, but it's not done in a way that makes clear that it's bonding time as opposed to birthing time, birth recovery time.
And that's the situation I see most often when I'm reviewing handbooks or policies, is really that latter situation where it's, 6 weeks of male parental leave and 12 weeks of, kind of as I mentioned in the beginning. And that's really where I see the most issue in policies that I look at. And really the solution often isn't fundamentally changing the leave that's being provided or kind of practically what's happening. It's really around changing what you're calling it and how you're identifying what amount of leave constitutes what, right? Whether it's bonding or whether it's medical leave, and how much you're giving of that, and is it reasonable? I mean, if all of a sudden you're giving, a woman who gave birth 6 months of leave and you're calling it medical leave, well now, and you're only giving, non-birthing parents like 6 weeks of bonding leave, is 6 months of medical leave really medical leave, or is this just bonding leave under another name, right? So there could be issues like that, but so really a lot of it is around the being really clear in your policy about what's what, and how you're in looking for potential impact or how you're treating people differently, and making sure that that's not the case, because this is something that's definitely been on the radar for the EEOC more recently.
Right. And I think you hit the nail on the head. It's really about being specific and carefully drafting the language of your policy to kind of account for these differences and make sure, this is what we're defining as recovery from birth time. And it's going to go into this bucket. And then over here, there's this other bucket for bonding time that applies equally across the board, and making sure that there's, like you said or alluded to, that, we're not saying it's 6 months for physical recovery. And I make no representation about whether or not women should be completely healed after 6 months and the impact of giving birth. However, from a disability and ability to work standpoint, usually we're talking in that 6 to 8 week window. The other point I wanted to make is, and we've talked about this generally previously on OK at Work, is FMLA is going to be running at the same time. So whatever the basis of the leave, if the employee is eligible for FMLA leave, you want to make sure that clock is running too, so you don't get through some portion of a paid parental leave, and then have the employee turn around and say, "Oh, you didn't run FMLA. I'm entitled to 12 weeks of unpaid leave now too."
Yeah, and to your point about not, the medical leave and when people are healed, these different pieces. Obviously, we're not doctors, so reserve on that. But it also could ADA could be triggered, with birthing parents. There's a lot of different pieces to be thinking about when it comes to parental leave, especially when there is a medical piece involved. But Title VII is something that also often gets overlooked. People are often thinking about FMLA, the ADA. They're thinking about the birthing parent, and they're thinking less about the bonding time aspect of things. But that's definitely changing. And we talk a lot about on this show, we talk a lot about retention. So that's also something to consider. I mean, a lot of policies are changing also from a retention standpoint about what's offered in the marketplace, and also state laws are changing. So there's a lot here, but don't forget about Title VII. It's definitely a big takeaway here today.
Agreed.
Awesome. Well, thank you, and we'll see you next time.
Thanks, Sarah.